You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg terminal. Bill, welcome.
Good day.
Let's start off by talking about Detroit. I know the big question about this case is the city's eligibility for municipal bankruptcy. It's not going to be decided until October, however. In the meantime, what are the big issues facing the case?
Well, the official committee representing retirees dropped a pretty good-sized bomb. They filed a motion technically called withdrawal of the reference because they believe that the whole shooting match about whether Detroit is eligible for bankruptcy should be decided in federal district court, not in bankruptcy court. I'm going to get out a bit on a limb here and say that I think the retirees actually might win a battle, but I suspect they're going to lose the war. They are raising a number of rather intriguing issues. First off, they contend that Chapter 9, the municipal bankruptcy law, is unconstitutional under the U.S. Constitution. They have a little bit of a problem because in the year 1906, in other words, more than 100 years ago, the U.S. Supreme Court held that a very similar statute, in fact, was constitutional. They have some other problems, however. They say that as a result of a Michigan constitutional provision and some Michigan state law, Detroit should not be in bankruptcy at all. And certainly they shouldn't be trying to impair municipal workers' pensions. And that's where they come into the notion of what's called withdrawal of the reference. They point to federal law saying that if the issue before the bankruptcy court turns on state law, the bankruptcy judge cannot issue final decisions on those sorts of disputes. And furthermore, under certain circumstances, the whole mess has to be taken out of bankruptcy court and moved upstairs to the federal district court.
How do you see this getting resolved?
Well, here's what I'm thinking. I hate to say this, Lee, but I think there is a decent shot that some of these issues that they raise either cannot be decided finally in the bankruptcy court, or in fact should be decided altogether in the federal district court. However, once you get beyond the question of who does it, at the end of the day, I have not been terribly impressed by a bunch of their arguments. And frankly, to me, or any sentient human being, I think, it's hard to imagine how Detroit, probably the sickest city in the United States of America, is not eligible for Chapter 9 municipal bankruptcy.
Right, and while all this happens, of course, Detroit is not getting any better. So we certainly hope this process speeds along. Got a new filing to talk about. After more than 6 weeks without a recognizable name entering the bankruptcy system, we finally have a major Chapter 11 filing by the company that makes furniture under a couple names. We have Thomasville, Drexel Heritage and Henredon. What's the case and what's it all about?
Well, by the way, as an aside, you're correct. August was very quiet. There were a total of only 5 public companies that went bust in August, and none of those are companies that you would recognize by name. Except perhaps if you live in Florida around Miami, you might know that the High Life Fronton and casino went bust in Miami.
It's a quiet month and a quiet year.
Yeah, you better believe it is. And we're halfway into September and not much to speak of except Furniture Brands, a good-sized company, has about $1 billion in sales. They have brand names among those that you mentioned. And they list about $550 million in assets and debt. And of course, as you know, in bankruptcy, Lee, assets tend to shrink and debt tends to enlarge. I'm also sad to say that this case, I think, is going to be another crashing bore. And that is because Oak Tree Capital Management has already come to the plate, signed up a contract to buy the whole business for a little bit under $170 million. Very often in cases like this, the buyer wants the sale to be completed, day after tomorrow. So, God forbid, nobody should come to court and force them to raise the price. In this particular circumstance, however, they're not intending to hold the auction until January. The skeptical part of me is wondering that they're putting off the auction because, frankly, they don't want to own this company until early 2014, closer, I suspect, to what is a better selling season. Oh, and by the way, I nearly forgot, Lee. Among filings of all sizes in Chapter 11 in the last, say, 2 months, New York City is losing out. Been almost nothing in New York. Everybody seems to be filing these days in Delaware.
Falling behind Delaware.
Well, you know,
that's a bit of a reversal from where we were maybe a year and a half ago,
it
right?
is. And I've been wondering why. And again, the skeptical part of me is saying, well, maybe it's because the poor old Delaware judges are getting more overloaded. And the more overloaded they are, the less attention they can give to a case. And if you are somebody who has a problem case, actually, you'd rather the judge have less attention rather than more.
But of course, we have two more Catholic dioceses that are about to take the plunge into bankruptcy. Where are they, and why are they approaching the precipice, as it were?
Well, they're not in any big cities. That is for sure. One of them is the Diocese of Gallup, New Mexico, and the other is Stockton, California. And of course, just like all of the other dioceses in bankruptcy, this is on account of sexual abuse by priests that occurred in many instances decades ago. Interestingly, the Gallup Diocese is very possibly the poorest Catholic diocese in the entire United States, even including the poverty-stricken Diocese of Anchorage.
Now,
Alaska.
how do we know that? Is that something we gleaned from the petition that was filed, or is that just a outside search?
I did a little investigating, asked some folks who ought to know, and that's what I came up with. The reason it's such a poor place is it essentially covers Indian reservations in northern New Mexico and Arizona. And Lord knows those folks don't have terribly much money at all. And of course, Stockton, the Stockton Diocese, that's in a city that itself is...
It's in a Chapter 9.
Yeah,
right.
Already in bankruptcy.
We already knew things weren't going too well in Stockton.
Yeah, that's right. So these, Lee, will be diocese bankruptcies number 9 and 10.
Wow, we're that high already.
Yep.
There's a lot of these.
Yep.
All right, well, we'll wait to see them as they come in. Finally, let's close out with the advance sheets. Usually at this point in the conversation, we're talking about a company no one has ever heard of, but today we actually have something that happened in the Madoff case. What happened in the liquidation of the biggest Ponzi scheme on record?
Burt Lifland, that marvelous bankruptcy judge who seems to have been on the bench since the flood, wrote himself another marvelous decision. I mean, this guy writes the best decisions on earth.
He's been at it a long time.
Oh, Lord, has he ever. He is really very good at what he does. The question was, do the customers of Bernie Madoff have a right to claim interest, that is, say, let's call it pre-bankruptcy interest, on the monies that they had given Madoff to invest? The issue, frankly, wasn't terribly complicated. It was, however, very important. Because for people who had had money invested with Madoff a long, long time, sometimes 20 years or more, if they got interest, even in a relatively small interest rate, on their claims, then that would give them proportionally much larger claims than people who were more recent investors. Burt Lifland wrote a wonderful opinion saying, unfortunately, the statute simply does not provide any means for giving interest to these people on their claims. Judge Lifland said that if there is a need for interest, this is something that Congress should address, but the bankruptcy courts don't have the power on their own to invent a rule of law giving interest on these claims. This is a very important case, Lee, not terribly so much because of the legal issue, but because the mere pendency of this dispute is preventing trustee Irving Picard from distributing, get this, $1.4 billion. That's how much Picard has got to hold back until this issue is finally resolved. And for that reason precisely, Judge Lifland, again doing a very smart thing, said he would allow the appeal to go directly to the U.S. Court of Appeals, thus perhaps foreshortening the whole process by, could be close to a year. The result of all of this means, I think, that assuming that Picard eventually wins in the Court of Appeals, it's probably not going to be until sometime around mid-2014 before he can distribute this $1.4 billion to the poor old suffering Madoff customers.
Lots of money. Bill, thanks for that.
You're welcome.
That's Bloomberg News Bankruptcy Columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go read his column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. I'm Pacchia. Thanks for watching.